The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. All right, we're happy to hear argument in Heish v. Bondi and Mr. Hashimoto. Are you?
Good morning, Your Honor.
Hashimoto.
Erica
Hashimoto.
Hashimoto.
Introduce student counsel for us.
Yes, Erica Hashimoto from Georgetown Law Center's Appellate Litigation Clinic, representing petitioner Kevin Shea. With the court's permission, Cameron Bakar, a third-year student in the clinic, will be presenting argument on behalf of Mr. Shea.
Well, we're delighted to have student counsel here and appreciate your assistance and that of student counsel. So step right on up.
Thank you.
Good morning, Your Honors, and may it please the court. Mr. Kevin Shea, a longtime permanent resident of this country, is not removable because his conviction under 18 U.S.C. Section 2422B is neither sexual abuse of a minor nor child abuse. Section 2422B was designed to criminalize a broad swath of conduct, including state statutory rape offenses that the Supreme Court has held are not sexual abuse of a minor, as well as adult-to-adult communications that do not involve a child at all. Section 2422B also requires only an intent to persuade, regardless of a defendant's intent to engage in any sexual activity. For each of these reasons, Section 2422B penalizes a broader swath of conduct than both the generic definitions of sexual abuse of a minor and child abuse. First, Section 2422B is not sexual abuse of a minor because it incorporates conduct prescribed by the same statutory rape law at issue in Escobar-Quintana that the Supreme Court held overbroad.
Haven't we kind of already decided this case with our decisions in Thompson with respect to the sexual abuse of a minor, and then the Cruz decision with the child abuse? I mean, we've got two precedents which seem highly relevant to the different prongs of the argument. So isn't there a significant stare decisis element to what we're dealing with?
No, first regarding Thompson, Section 2422B is a substantially different statute than the statute at issue in Thompson. First, because of the custodial relationship requirement in the statute in Thompson, and then also with the mens rea element that was present in Thompson that is not present in the lascivious intent. That is not present in Section 2422B. This case, or this argument is this statute is a much broader statute than the one in Thompson. And then regarding Cruz, the holding in Escobar-Quintana explained that not all sexual activity with consensual sexual activity between 16 and 17-year-olds is inherently harmful. And the argument that we are making regarding child abuse is that in 1996, when Congress added the term into the INA, consensual sexual activity of the person 16 or older was not considered categorically harmful.
Do I understand you to say that engaging a child in sexual activity is not child abuse? Is that what you're arguing?
No, in the context of in the context of our Escobar-Quintana argument, or in the context of child abuse.
Child abuse. Child abuse seems to be any activity which threatens harm to a child. And it seems to me if you take the conduct identified in 2422, both having a child engage in prostitution or having a child engage in sexual activity is child abuse. Having a child engage in sexual activity is harmful. It's the whole area of regulating sexual activity of children and harming children and child pornography starts with the presumption that having children be engaged in sexual activity by somebody else, whether by prostitution or some other activity, is child abuse. I'm puzzled why, what exception to 2422 conduct wouldn't be thought of as child abuse.
Congress added or created Section 2422B to be a broad statute and to penalize a broad swath of conduct.
But you're suggesting that the conduct of 2422 is not child abuse. It's broader than child abuse. It seems to me everything in 2422 is abusive in a child. Having a child be engaged in prostitution or having a child being engaged in sexual activity is prohibited by 2422. And it's prohibited because it's abusive of children, isn't it?
Well, Section 2422B can be applied broader than in those contexts. And under the
give me a hypothetical where you would violate 2422 and it wouldn't constitute child abuse.
One example would be that a defendant can violate Section 2422B for solely engaging in adult-to-adult communications without any involvement of a minor. There are cases in this circuit and in other circuits where defendants have been convicted under Section 2422B for communicating with law enforcement officers posing as parents or caretakers.
Yeah, but those are attempt violations. I mean, they're undercover, or they're posing as the child. But that doesn't mean the statute isn't violated, because the statute covers not only the conduct, but the attempt to do so. And that is disposed of in the attempt portion. But I'm trying to figure out what conduct that is prohibited, set aside the undercover circumstance which catches the attempts, what conduct is not child abuse?
Another example is the example presented in Escobar-Quintana, where a 21-year-old defendant could violate the California statutory rape law for engaging in sexual intercourse with his 17-year-old girlfriend. And because that activity is prohibited in California, that would be considered a violation. Because Section 2422B incorporates statutory rape, including the California statutory rape law at issue in Escobar-Quintana, it also—
You have to ask yourself a general question, and that is, you know, what does Congress want? And they want someone convicted of an aggravated felony to be deportable, and it's hard to imagine really that somebody who is convicted of 2422, that coercion and enticement of a minor for purposes of sexual gratification, that's exactly the kind of individual that Congress would want removed from this country. I just don't see how we can say that enticement of a minor, and it has, under a statute which requires knowing persuasion directed at somebody younger than 18 for the purposes of sexual gratification. It seems the 2422 conviction seems right in the heartland of sexual abuse of of a minor, and right at the heart of what Congress intended. Its statute, the kind of conduct it intended the statute to cover. That it's just a practical application of congressional intent, is it not?
I don't believe that the statute, Section 2422B, falls within the generic definition of sexual abuse of a minor because Congress intended it to be a broad statute and incorporating this fourth element that includes both state and federal offenses. And in the context of sexual abuse of a minor, the Esteval-Quintana decision found that statutory rape in a state like California was overbroad compared to sexual abuse of a minor because consensual sexual activity between, for example, a 21-year-old defendant and a 17-year-old minor is not sexual abuse of a minor because the age of consent in that context, or in the context of sexual abuse of a minor, is the age of 16. And the only addition for Section 2422B would be the interstate commerce element, and so that could be satisfied by a 21-year-old defendant communicating over text with a 17-year-old defendant. And also,
well, you know, the intent of Congress, and when we look at a statute and says we can look at it ourselves and say sexual abuse is one way of doing it, but what is the issue in this case? Our determination, you're not here simply because of that. We could have just looked at this statute and said that's it, and that would be the end of it. You wouldn't even be standing here. But there's a deeper issue in this case as to why you're having this type of analysis as to whether this is a generic offense, whether it's overbroad, the whole bit. What is the issue, and why is it that's the legal issue in the case? The factual matters you just discussed are really interesting. Nice things to talk about. Says, well, how can that not be sexual abuse? That's not the issue in the case. We're dealing with the legal issue in the case, and how do you frame that?
in the context of sexual abuse of a minor, and in this case is regarding the categorical approach and what is the minimum conduct criminalized under Section 2422B.
So break it down from the beginning. I mean, you're dealing with an immigration case. You're dealing with a removal situation. Why does this issue arise in this context?
Because Section 2422B is such a broad statute. In addition to the...
and why is that important?
Because Section 2422B, because it criminalizes more conduct than what falls under the generic definitions of sexual abuse of a minor.
Well, why is that a big deal? Because obviously it doesn't make a big deal to some. If it's overbroad, it doesn't matter if it has that type. Why is it that clearly you can look at it, yes, it does encompass, but if it was overbroad, why is that important?
Because if Section 2422B, if this court finds that Section 2422B is overbroad compared to sexual abuse of a minor, then Mr. Shea would not be, it would not be considered a removable charge for under the INA for Mr. Shea in the context of sexual abuse of a minor. And our other argument regarding sexual abuse of a minor is that defendants have been convicted under sexual abuse under Section 2422B for adult-to-adult communications without any involvement of a minor. And sexual abuse of a minor, by contrast, requires the misuse or maltreatment of a minor to complete the act of abuse.
So why is the mens rea in 2422B broader than that in the sexual abuse of a minor?
Because Section 2422B only requires a defendant, only requires an intentional attempt to obtain a minor's assent, regardless of whether a defendant intends to engage in sexual activity.
2422 requires knowing persuasion, does it not?
Yes, Your Honor.
So why isn't that a satisfactory mens rea if it requires knowing persuasion? And as I say, not only knowing persuasion in the abstract, but knowing persuasion directed at someone younger than 18, and knowing persuasion for purposes of sexual gratification. And why can't that be a lawful predicate for the a general, generic offense of sexual abuse of a minor. They seem to map onto each other, do they not? They map onto each other pretty doggone well.
No, Your Honor, because this court in Angle clarified that the intent to persuade and the follow-up intent to perform the act after persuasion are, quote, separate and different intents. And this court further clarified that Congress expressly intended for Section 2422B to criminalize persuasion and the attempt to persuade, rather than the performance of sexual acts themselves. And in the context of sexual abuse of a minor, the intent to achieve sexual, or to, the intent to,
So I'm just trying to apply a categorical approach here, which it seems to me is very problematic for purposes of your client. The Supreme Court instructs us not to go around imagining hypotheticals that might conceivably somehow broaden the predicate to a point where it can no longer serve as a predicate for the generic offense. But we would really have to stretch our imaginations in this case to get this conviction to be something substantially broader than the generic offense. And I think the Supreme Court has been pretty clear in telling us, don't do that. The categorical approach does not require that. You see the problem?
no, Your Honor, because the intent to persuade is a broader intent than the attempt to achieve sexual gratification. And if we look at this court's decision in Larios-Reyes, where the court found a Maryland statute overbroad because a defendant could engage in conduct with a minor that was injurious, harmful, or offensive, but not necessarily sexually gratifying, a defendant can be convicted under Section 2422B without an intent to achieve sexual gratification. The only requirement is the intent to persuade. And
thank you very much, counsel. And wait a minute, let me see if my co-panelists have questions of you. Judge Niemeyer?
No, I'm fine, thank you.
Judge Wynn, do you have further? We thank you very much, and you're going to have some rebuttal time as well, okay?
thank you, Your Honor.
Ms. Glazer?
Good morning, Your Honors. May it please the Court, my name is Sherry Glazer, and I'm here representing the United States Attorney General. Your Honors, 18 U.S.C. 2422 subsection B is a categorical match to this Court's generic definition of sexual abuse of a minor, as well as a crime of child abuse. I'm happy to start. I have 4 points to make, if Your Honors don't mind, on the Esquivel-Quintana argument that petitioner has raised. This court is bound by Thompson, and in Thompson, this court looked at Esquivel-Quintana and held that the holding in that case was very narrow, that it only applies to a sexual abuse of a minor offense when you're dealing with a strict liability statutory rape offense that criminalizes conduct solely based on the ages of the participants. And that's not what 2422B is. It's not a strict liability statutory rape offense.
We can't look at the underlying offense. We've just got to approach it categorically, and it seemed to me that the combination of Thompson and Cruz pretty well, sometimes precedents only answer 90% of the question, but these two precedents, both with respect to child abuse and sexual abuse of a minor, these are 90% precedents. They answer it. Cruz probably answers it 100%, and Thompson answers it 90%, because the whole question was whether the Esquino, Quintana, or what have you, the Supreme Court, how broadly that extended, and then Thompson says no, that's limited to statutory rape, where we know that in instances of that, there's no mens rea. And then Thompson came along and say, well, you know, where you have a situation where there's clear that there is a mens rea, that wasn't covered by Esquino, Quintana, or whatever, and the distinction seems to me between statutory rape and knowing persuasion of an abuse of a child to be the distinction between those offenses seems rather dramatic.
I agree with you, Your Honor, and I would point out to the extent that I believe I understand petitioner's argument when he's trying to say that somehow 2422B incorporates statutory rape or encompasses it. It doesn't. It criminalizes that knowing persuasion, coercion, inducement, enticement of an individual believed to be under 18 to engage in prostitution or some sort of illegal sexual activity, but it is in no way dependent on a criminalization of statutory rape or of that illegal sexual activity. It is quite self-contained, and so that argument, just to point out for the court, it really leads to nowhere. And to the extent that, I believe it was in the reply that petitioner cited People versus, I believe it's pronounced Ranch, R-A-N-S-C-H-T, to argue that all offenses have a mens rea, including these strict liability statutory rape offenses. That was an equal protection case. And it was looking at 261.5 under the California Penal Code and Section 288. I cannot remember the subsection, but the argument was one, if you're convicted of one of the statutes, that you're required to register as a lifetime sex offender. And if you're convicted on the other one, you're not. That's all that case addressed. And there's one line in the case that says, that addresses an argument and distinguishes the two statutes and says that 261.5 is more general intent only because it does not require proof that 288 does, that the defendant wanted to satisfy his own sexual desires or the sexual desires of the victim. It does not say, like petitioner is trying to argue, that under 261.5 you have to prove that the defendant wanted to engage in sexual intercourse. That's just not what the case stands for at all, and I just wanted to point that out.
But from the perspective of 2422B, there does seem to be an incorporation of those statutory rape laws, such as the ones that deal with this term illegal sexual activity. That would bring in the state laws that the Supreme Court has found that are overbroad, insofar as the height and age concept within it, and the features of being a statutory rape basis where we are. Is there not a difference? And is it not incorporated within this?
No, Your Honor, I respectfully disagree. I don't think it is, because it doesn't matter for purposes of a conviction under 2422B whether any sexual activity actually happened. All that matters is the prosecutor proves beyond a reasonable doubt that the defendant knowingly persuaded, induced, coerced, enticed someone he believed to be under the age of 18 to engage in prostitution or some sort of illegal sexual activity. But it does not.
Is there any circuit that disagrees with you on that?
I'm sorry?
Any circuit that disagrees with you on that? In the Ninth Circuit in Tello?
I'm not aware of any court that holds that under 2422B you have to actually show that the illegal sexual activity happens and that's somehow incorporated. I'm not aware of any case that says that. And I would also point out the hypothetical that petitioner brings up, that a defendant who's 21 years old and texts his girlfriend who's just about to turn 18 to engage in consensual sexual activity. You know, that doesn't even fall under what 2422B criminalizes. Yes, so the victim, the so-called victim in that case is under 18, yes. But it doesn't have that knowing persuasion, coercion, inducement, enticement element in that hypothetical. So it doesn't even fall into what 2422B actually criminalizes. And petitioner doesn't point to any case where there is actually a prosecution under 2422B that applies strictly to that scenario. Petitioner cites Tello. The victim there was a law enforcement officer posing as a 13-year-old. In Kelly, the victim was 16. The defendant was at least 21, because we know that because of other statutes that he was convicted under. Petitioner cites Ogden. The victim was 15 when the offense started in that case and then turned 16. And then in the reply, petitioner cites Kayaki to make the argument that 2422B would even cover a scenario where a defendant was 18 and texted a 17-year-old to engage in consensual sexual activity. And I'll just point out for the court that the defendant in that case was 29 and the victim was 15. So that doesn't support petitioner's argument either. And regarding the argument that 2422B does not meet the requirement in sexual abuse of a minor, that it's for a purpose associated with sexual gratification, the government disagrees with that. When you look at these cases and you look at the conversations that are criminalized under the statute, they're not innocent and pure conversations. They're extremely unpleasant conversations to read. They're conversations where the defendant is talking to these children about what their bodies look like, whether they've done certain things to themselves, done things to other people, whether they would agree to do certain things to them. And there is no, petitioner doesn't suggest any reason, and the government cannot think of one, as to how that's not all for a purpose associated with sexual gratification. I'm happy to.
Let me ask you something,
Sure.
just practically. This is a deportation case for removal, and the defendant here has been sentenced to 276 months in prison.
Mm-hmm.
What does that mean? That mean you take him out of prison and send him back, and he doesn't serve the punishment for the 276?
No, he would serve his full federal sentence, and then he would be sent back.
So we are talking about once he completes the 276 months.
Yes,
How many years from now?
23. Oh, how many years has he been serving now?
Yes,
That's a really good question, Your Honor.
not long.
I don't think it has been. No,
So
so
we're
he
talking
has
about
quite a bit.
something-
He had quite a bit of time left.
So the practical fact, he'll be deported when?
Yeah,
20 years from now?
around that, I would say. It's between 15 and 20. To be honest, I can't remember the exact timeline.
So the deportation won't happen at all right now?
Right now, correct? Because he committed this crime here, and yes, he does have to serve his full federal sentence.
So he'll be here in the United States,
Mhm.
in prison,
Yes.
for 20 more years. And I suppose it's kind of an odd situation. If you want to remove someone, deport them, who knows what the world's going to be like in 20 years? Or longer than 20 years, actually 276 months, and he's not served very long at all.
Right.
Okay.
Yeah. And I'm happy to address. There's another issue that
It just seems like it's something that could come up later. I mean,
Sometimes it does.
Why do we need to talk about something that's going to happen 20 years from now? Why don't you deport him when he can be deported 20 years from now, and then let him address this? Or I guess because, now, what happens if in 20 years you see the case laws have changed? They're changing in the Fourth Circuit all the time. They're changing on the Supreme Court. And then when he's actually being deported, is he going to be deported under the laws that exist now, or the ones that will exist 20 years from now?
If between now and when he finishes his federal sentence.
So my answer, my question is that he will be deported based upon the laws 20 years from now?
No.
So the laws that will occur before he's deported will not be applicable to him?
No, not necessarily, and that's where I was going with my answer. So, yes, this court decides his case. If anything does happen to change, I don't know that, you don't know that. I don't know if anything with regards to these two particular issues will change. But if it does, he can always file a motion to reopen, and he can say there's been a change of law, and I am now no longer removable. I have seen that happen, so
he
in
was
answer to your question, I don't
indicted
know.
in November of 2018,
Mhm.
and then this action, I guess the conviction then takes place, and then now this comes up 2022.
Yeah.
Is this a choice on the part of the government to proceed now? Could you do it now, or could you do it later?
I've seen cases where it happens in a timeline like this, and I have seen cases where people are in prison for whatever the conviction happens to be, and removal proceedings happen later.
And you don't think that 20 years from now, when this actual deportation is then being processed, if this law is upheld, that there won't be some court action to say, based upon some laws, or Congress could have done something totally different 20 years from now, he's no longer in that position? So we're talking about, I guess, conditional deportation or whatever. You're not going to deport him. I mean, if you're not sending anyone away for 20 years, I would call that's not deporting. At least it's maybe in an order saying he will be deported. But why, and what is the law that says if you're in prison and you're being deported, you're not deported now? Could he be deported now?
I think that would take a lot of coordination. You know, it would take involvement of the U.S. Attorney's Office, whoever handled this. I imagine the Bureau of Prisons would have to get involved.
India would have to agree, I guess.
I'm sorry, I didn't hear you.
India would have to agree, I guess.
Yeah, India would
also. It could be put in
yeah.
prison in India.
I don't know how that works. That's not an issue in this case. But to answer your question,
Well, that happens a lot. I mean, it happens when you individuals in prison in another country, and they can come here and serve out their sentence, or depending on the countries that are working in it. I mean, it's not a shrugging matter. It's we are a court here. I doubt I will even be here 20 years from now when this all comes up, and I'm sitting here talking about a deportation that in my mind may or may not even happen. It may happen in your mind, but you can't possibly tell what the Congress or what this country is going to be doing in 20, 24 years from now. I just don't get it. I don't understand why you, other than just, I guess, to say he is deportable, or he will be deported upon so there won't be any, I guess this will be, there won't be any subsequent actions against him once he gets out of prison. In other words, he won't be on probation. None of that will happen during that time period. But by then, his family, he has 2 children who are American citizens. I guess his wife is an American citizen too, will be here. All right, we have to answer the question before us, and I mean, somebody thinks this is important to do this now, maybe to preserve the evidence because of when it's being done. But it certainly doesn't make sense to me to say, we're going to do something. It's almost like taking you to a regular court for a criminal offense and says, well, he'll go to jail 24 years from now. But whatever he's doing, let him keep doing it until then. And I guess, but you say there's a choice, and that choice is made by is it made by your office, solicitor, or who makes that choice?
Whoever, DHS initiates proceedings, so.
And can they go one way or the other on it? They can decide, yes, we're going to do it now, or no, we're not going to do it now?
I mean, all I can say is that I have seen cases where someone is convicted and towards the end of the sentence is when removal proceedings are initiated, whether that's because that's when it is discovered that the individual is a non-citizen. Since I'm not behind the scenes at DHS, I don't know what leads to that.
Counsel, I don't want to get, my colleague raises good points, as he always does, but I don't want to get too far away from the discrete question before us, which is whether the 24-22 conviction qualifies as a predicate in these cases and qualifies as a reasonable offense. I don't think we can crystal ball what how the consequences are going to spool out 1, 5, 10, 20 years from now. It's hard to know. At a minimum, we have a good many situations where someone is ruled deportable and someone has also committed a crime for which imprisonment could be imposed. And what it does in these dual situations is it gives the executive branch greater flexibility and options in terms of imprisonment or deportability. And that question is often posed to DOJ as to what route should be taken with respect to which individuals. And I don't know how I can crystal ball it, but, you know, the best I can do is to try to answer conscientiously, according to the law, the question that's been posed to me. That's the best I can do. I can't, I don't know, I'm not terribly adept at looking far into the future.
Yeah.
I will readily concede in greater sense.
I want to also make it clear, though, at least for my good colleague here, that the interest here, yes, we do want to look at this law, but when we do things on this court here, you kind of like to know how it really is going to play out. We are looking at the statute as it is now. You got Thompson that was just handed down, changed the law a little bit, and you got Ingalls, you got other cases in here. This is a moving target. It's even on a federal level, it's a moving target, this whole deportation stuff that's going on. I'm not bringing anything, I'm just saying that it is a legitimate question to ask you, the government, that makes a decision of whether to do it now or to do it 23 years ago, what is going into the thought process. And it's a legitimate question to know when he's up for deportation 23 years from now, will the law that we are citing here be applied, or will he have the benefit of the laws, or benefit or detriment of the laws that will be in existence then? And it just seems to me that if you want to take an act of deportating someone, and it's not going to happen until 23 years from now, for which, as I said, it's a good shot I won't be around for that, or a lot of other people won't be around for it, but it's a long ways. That's the only purpose of asking the question is, what is the nature of the laws? And yes, we can look at it as it is now, and then we just say, oh, that's it. But 23 years is going to go before anything happens here. He's not going anywhere, as far as I understand, unless somebody lets him out. I mean, maybe he'll get out and then he'll go somewhere. But that's the only purpose of asking the question. I think you've done a good job of bringing it up, and probably like me, you don't really know the answer as to why they do this.
Right.
So we're good.
I don't. All I can say is, yes, it's the court's job to apply the law today, and if there is some sort of change, which we don't know, between now and when he is released, once the court issues this, he always has the option to file a motion to reopen if there is some enormous change in law that he believes will alter his removability.
See,
He always
it brings
has
into
that
question,
chance,
additional
but I
question,
don't
we
know.
say, as the law is today, it does bring into question as well, if you wait 23 years, there are a lot of things that, there are actions that make things stale and over time. I mean, I don't know. I'm just saying, that's the only purpose. I mean, you don't need to go any further with it. I'm just saying, this creates to me a question. When the government's standing to me saying, deport someone, and it won't happen for 23 years, because he's going to serve most of his sentence unless something happens in between it. That's the only reason for bringing that up.
I can understand why you bring it up. I can understand this creates a little bit of a different case procedurally than most that are addressed.
I didn't see anything like it anywhere else.
There's an old bromide called sufficient unto the day. And it's not ill-fitting if an individual judge wants to take a modest conception of his or her role. That's no profound pronouncement, but, sometimes sufficient unto the day. Justice Frankfurter had a wonderful comment, and he said, we should not try to do too much lest the future embarrass us. And Justice Frankfurter's comment about not be embarrassed by the future, by trying to script the future. It may have some applicability here.
That is true. It's truly an impossible thing to do, so I don't know what the future's going to bring.
But, it also brings in the whole controversy. I mean, we don't deal with things unless there's an adversarial or it's a situation in which you have a controversy at hand. And right now, we don't have a problem. He's going to be in the United States for 23 years.
the whole purpose of deporting him for 23 years won't mean anything. There will come a time when he's released, then it actually will become something. But right now, he's here. But I defer to the great Sir Frankfurter and the great Judge Wilkerson.
Well, unless your honors have any more questions, I'm much over my time. Thank you very much.
All right, we thank you very much. And Ms. Picard, we'd be happy to hear from you in rebuttal. You have some rebuttal time.
And you won't be asked about that.
Well, I was just.
At least I won't.
I have 3 points for rebuttal. First being that I want to point out that the Supreme Court in Escobar-Quintana engaged in the analysis when it determined what the minimum conduct under the California statute was, and it looked at Congress's intent and came to the conclusion that that California statutory rape law was overbroad compared to sexual abuse of a minor in the context of statutory rape. And we asked this court to perform the same analysis to determine that because a defendant can violate Section 2422B for engaging in internet conversations with an intent to violate a statute like the California statutory rape law at issue in Escobar-Quintana, it is also facially overbroad. And the actual cases that were brought up, for example, in Tello, show that defendants are convicted under Section 2422B for engaging in internet conversations with an intent to violate statutes such as the California statute.
You do recognize that. It appears to me that Thompson disposes of that very argument, taking the Supreme Court's decision for what it says, that it's basically focused on the differential in age alone as the violation, in that the broader scope, which includes mens reas and other aspects of 2422, distinguish that case and this case.
Well, the statute at issue in Thompson had that lascivious intent, a specific intent, and Section 2422B has a more general intent of just the intent to persuade, and that is more similar to the general intent required under statutory rape. And also, the argument that we are making is closer to the Fifth Circuit's decision in Schroff v. Sessions, where the court found that after Escobar-Quintana, a conviction for online solicitation of a minor in Texas, where the age of consent was 17, was overbroad compared to sexual abuse of a minor. And the court found that, or the reason that an online solicitation between a 17-year-old and an almost 18-year-old and a 21-year-old defendant cannot be categorically, especially egregious conduct in the context of sexual abuse of a minor, if actual intercourse between a 17-year-old and 21-year-old is not. And my last comment regarding the crime of child abuse, the example in Cruz explained that the substantial step required for the crime of child abuse is a reasonable probability of harm. And it used the example of the defendant, or a defendant can throw a heavy object and miss a child and it still be considered a reasonable probability, but there still has to be a reasonable probability of harm to a child. But
well, that's hardly this statute. This statute talks about inducing a child to engage in sexual activity that would be illegal, and that's hardly throwing a pipe at the child. Now, your argument, I guess, goes to whether there's child abuse, but it seems to me that child abuse might arise out of that circumstance also, but we don't have that before us. We have a statute that requires that the defendant actually induced the victim to engage in illegal sexual activity, and he was convicted of that. And the question is whether that conviction categorically amounts to child abuse, and My question initially out of the gate was, I have not figured out an example why that wouldn't be child abuse. But
I see my time is up. May I answer your question?
sure.
The example that I brought up regarding Cruz, in the context of Section 2422B, there doesn't have to be a child in the vicinity. Defendants are convicted convicted under Section 2422B, even if there is no communications with a child, and there's only adult-to-adult communications. And
Well, of course,
looking
that's
at
the
the
attempt
minimum.
part, right?
Yes, and Section
And
2422.
the actual commission of the crime doesn't involve committing it with an adult. It says committing it with someone under the age of 18, right?
Or the attempt to do so.
Well,
And
right, that's another aspect.
yes, and under the categorical approach, we have to look at the minimum conduct, which includes the adult-to-adult communications.
Thank you.
Thank you.
Thank you very much, and I want to say how much we appreciate always having student counsel here. And you've done a fine job, and we really appreciate it. We'll come down and greet counsel and move into our next case. We're here, our next case, Extra Energy versus the Department of Workers' Compensation Programs, and Mr. Grigoracci.
Yes, Your Honor.
We'd be happy to hear from you.
Thank you. Yes, may it please the court, Mark Grigoracci representing the petitioner, Extra Energy. I think I've reserved about 5 minutes for rebuttal. So Mr. Lawson is a coal miner. He has 12 years of surface coal mine employment that ended in 2014. He also has a very heavy smoking history, consisting of about 1 pack per day for 30 years, starting at around age 16, then regularly smoking by age 24 through age 55. In this federal black lung claim, Mr. Lawson has the burden of proving that he has a chronic lung disease or impairment arising out of coal mine employment, i.e. that he has legal pneumoconiosis. On these facts, this federal black lung case raises a simple question. Does Mr. Lawson, or does the claimant prove black lung merely with a formula that smoking plus coal mine dust exposure equals legal pneumoconiosis? The ALJ and BRB below think that this formula is enough. However, this formula is an abandonment of the required analysis of medical evidence in federal black lung claims. Worse, it was used to impose the burden of proof on the employer to explain why Mr. Lawson doesn't have legal pneumoconiosis. However, no explanation could ever be accepted by the administrative law judge. According to the administrative law judge, the effects of smoking and coal mine dust exposure must always be additive. Smoking and coal mine dust exposure must always combine to cause pulmonary impairment. Nothing can ever separate the two effects, and hence there's always legal pneumoconiosis when you have a coal miner who smoked. This is a fundamental error of law requiring a reversal of the award of benefits in this case.
Would you say that American Energy, our recent case, is a case that probably is guiding quite a bit of your discussion today?
Yes, Your Honor, it is. And
If we agree with you, and with a case that just come out, should we just send that back and allow this matter to be considered in light of that case?
that is an option, Your Honor. I think if this court were to view Mr. Lawson's experts under the standard of American Energy, it's going to be clear that Mr. Lawson didn't even meet his burden of proof. So in that situation, failure of burden of proof, the evidence at best is tied, the petitioner should win.
When we look at the previous cases, Courtroom and the others, and then American Energy comes around, I think it can be distinguished. I don't think there's a conflict there. It's just a different type of case. But it did add something to the law that wasn't present when this matter was being decided by the ALJ and others. So if we did agree with you, it just seems like it's a case that's more right to send back and allow the bodies in the first instance to consider this matter in that light. Because to consider it under previous cases, it would seem to me as though we very well could say they did everything right. Could, I'm saying. But it becomes very difficult when you're looking at American Energy. So you follow me on that?
Judge, when I respect your position, I respect that argument. I think American Energy clarified what was already the burden of Mr. Lawson to prove his claim. And I think if you take those previous cases and American Energy, recognizing that Mr. Lawson always had the burden to prove that he has lung disease arising out of coal mine dust exposure, when his experts say, well, sure he has legal pneumoconiosis, and you say, why? They say, well, because he smoked and has coal mine dust exposure. That's a failure of the burden of proof. I think even if this were to be sent back and for reconsideration and say, well, what's the outcome? The outcome should be that he has failed in his burden of proof. But if this court were inclined to reverse and remand, that certainly is an option, and that's better than an affirmance of this award of benefits, because it's clear substantial evidence does not support the award of benefits. I mean, we have the ALJ, the administrative law judge, finding Mr. Lawson's medical experts credible simply because they say he's got these dual risk factors of smoking and coal mine dust exposure. They must be additive, so we're going to add them together. There's the formula. Smoking plus coal mine dust exposure must equal legal pneumoconiosis. But American Energy and this court's other decisions also make it clear that is not enough. You can't simply just add them together and say, well, there's legal pneumoconiosis. We can't figure out which one is which. It's on the claimants, on Mr. Lawson, to present affirmative evidence that he has a connection to coal mine dust exposure. And it's very clear in this case that the ALJ, the administrative law judge, the only reason that the administrative law judge is finding Mr. Lawson's experts credible is because they identify these two risk factors. I mean, as to Dr. Forehand, one of Mr. Lawson's experts, the administrative law judge says that, well, Dr. Forehand's opinion, quote, is consistent with the medical evidence and the resolution by the Department of Labor to scientific and medical issues concerning the effects of smoking and coal mine dust exposure. Oh, there it is. He said both of those two things. Must be well reasoned. American Energy and this court's previous decisions say that such an analysis is completely invalid. It was done again as to Dr. Green, one of Mr. Lawson's other experts. According to the administrative law judge, this opinion from Dr. Green is credible because it's generally, quote, generally well-reasoned and documented, as well as consistent with the regulations and their scientific and medical basis as set forth in the preamble. Well, this court in American Energy said that it's invalid, prejudicial legal error for an administrative law judge to credit a medical expert's opinion of legal pneumoconiosis merely because it's consistent with the preamble. That is exactly what the ALJ said.
What about the Westmoreland case? I mean, that's a case in which the court did consider a situation where there was testimony that both dust and cigarette smoke were causes. And the court there took the position that was enough for the ALJ's conclusion that these ailments were caused in part by the coal mine dust there. How does that case, how do you address that case in terms of its application here?
Judge Wynn, we have to look then to the further explanation and clarification from American Energy. Because I think the Westmoreland case that you're talking about was wrongly decided. I think when a physician is saying, as in this case.
Well, if it was wrongly decided, who can overturn it?
Well, this court has the published decision in American Energy, which sets forth the appropriate standard for assessing the medical opinions in this case.
Well, we've got to reconcile it, don't we? I mean, we wouldn't say that American Energy came back and overruled or set aside our opinion in Westmoreland, would we?
No, Your Honor. I think.
So we've got to reconcile the two opinions. I mean, you know, it's just the way. I'm not saying it can't be done, but to say it was wrongly decided, it may have been, but we can't come back and say, we can't write something and say it was wrongly decided from a previous panel or previous decision.
That's correct. And I apologize, Judge Wynn. I'm not suggesting that this court or this panel would reverse Westmoreland. So
my point being is, and I'm not being argumentative, I'm just saying that if American Energy changed the legal landscape, and that was not the benefit that the ALJ or the BIA had in making its decisions, it would seem to me that if we did agree with you, it just doesn't seem appropriate to just reverse it, because they didn't have that. We don't know how this would have played out there, even though you strongly feel one way or the other. That's the point I'm making.
I understand that position. I disagree with it, Judge Wynn, but that is an option. If there is one option in this case is not to affirm the award of benefits. I mean, that is not an option here.
You'll take anything you can get at the first instance, but you like more.
Correct, Your Honor. And I think it has always been, and American Energy stated essentially as much, it has always been, in this type of case, Mr. Lawson, as the claimant in this federal black loan claim, has always had the burden of proof. He has got to put forth evidence that his COPD is not due to 30 years of smoking. But he's got to show that it's at least due to 12 years of coal mine employment. And what his physicians here say, what his experts say is, well, yeah, you've got both factors. They must combine, and therefore he has legal pneumoconiosis. Under the previous cases and under American Energy, that is legally deficient. And again, we have the administrative law judge here as to the third expert, Dr. Raj, just to round that out, making it very clear that it's simply the identification of these two dual risk factors that could be causing Mr. Lawson's obstructive lung disease. That's the reason why these opinions are credible. So the administrative law judge indicated that Dr. Raj's opinion on this legal pneumoconiosis is, quote, consistent with the regulations and their scientific and medical basis. Well, what he's saying there is Dr. Raj has identified smoking, identified coal mine dust exposure. The preamble and the regulations say that those can be additive. The administrative law judge takes it a step further, adds them together, and says, there it is. There's your legal pneumoconiosis. But American Energy has clearly identified that such an analysis is wholly deficient, and it cannot sustain the award of benefits. And in fact, the analysis and the administrative law judge in this case is remarkably similar to what this court, or the panel of this court, found wrong in American Energy. I mean, there the administrative law judge credited the opinions because they identified two risk factors, and then there the administrative law judge said that the experts also identified coal dust exposure as a contributing factor, and then that they were just consistent with the regulations in the preamble. That kind of analysis, which was done in this case as to the three experts relied on by Mr. Lawson, is wholly invalid. And we know here that it's clear that these three experts, Dr. Forehand, Dr. Raj, and Dr. Green, have reached their conclusion as to legal pneumoconiosis, or that is lung disease arising out of coal mine employment, simply by doing a formula. Add smoking, add coal dust exposure, there's your conclusion. Dr. Forehand, he states, because if you drill down deep into their opinion, Dr. Forehand states that Why is there legal pneumoconiosis? Well, here's the answer. Because there's, quote, parallel exposure to cigarette smoke for 27 years and occupational exposure to coal mine dust. Okay, well, both factors exist. Which one is it? That's the problem. Dr. Green is no better. Dr. Green indicates that smoking, quote, the smoking history is a factor to be considered in the diagnosis. This gentleman's 12-year occupational history of exposure to respirable coal and rock dust is an additional significant factor. Well, we understand that. Where is the rest of the analysis? And Dr. Raj makes it even clearer that it simply is a formula that they're applying without any analysis. Dr. Raj, whom Mr. Lawson relies on, says that Mr. Lawson has, quote, COPD resulting from exposure to coal/rock dust for a total of 12 years in coal mine employment and cigarette smoking. Both smoking and coal/rock dust rock dust exposure are a well-known risk factor to cause COPD. That is the extent of the analysis. Both factors exist. American Energy said that the claimant cannot prove legal pneumoconiosis, which is what Mr. Lawson has to prove, by solely relying on evidence equally indicative of coal dust-induced lung disease and smoking-induced lung disease.
Now, sometimes it's best not to make a simple matter complicated. Woody Guthrie, you're familiar with Woody Guthrie, who's a great American troubadour, and he said any fool can make a matter complicated. Only a genius can make it simple. And so I'm asking you why it's any more complicated than having a dueling set of experts come to different conclusions, and the ALJ credited one set of experts, but why isn't that a matter of credibility? Why isn't that the very thing that ALJs are supposed to do? And this wasn't something where an ALJ ran off the tracks. He said that the coal mine employment had contributed in substantial part to the total disability. And the ALJ made a credibility finding, and why isn't that the sum and substance of it?
I appreciate that question, Judge Wilkinson. In this case, there was no battle of the experts, nor was there any credibility assessment. What we have here is the administrative law judge coming in to this case and saying the physicians that say Mr. Lawson's 30-year smoking history is not the sole cause of his impairment, those are credible. Why? Because they say he's a coal miner who smoked. That is not a credibility analysis. That is not an assessment of the experts. I see my time has expired.
Got some rebuttal time unless one of my co-panelists has questions. Paul? All right, thank you. Mr. Austin, let's hear your side of it.
Good morning, Judge Wilkinson. May it please the court.
Can you get the microphone as close as possible, because it's a very cavernous courtroom and the acoustics are lousy.
Sure. It was my honor to be here yesterday on a separate case, and I'm happy to be back this morning. It's always a pleasure to be before the Fourth Circuit. May it please the court, I'm Brad Austin. I represent the coal miner in this case, Mr. Glenn Lawson. Judge Wilkinson, I appreciated the last question you asked to Mr. Grigarachi. That's the very point I'm here to make today. In this case, it was a battle of the experts. The administrative law judge considered 5 different medical opinions separately, gave weight to 3, gave less weight to 2. That is a battle of the expert. That is a substantial evidence consideration, and this court, as it knows, does not go in and reweigh the evidence. It applies a deferential, substantial evidence analysis.
And we can always pick it apart, and we can always redo it and everything. but I don't know, the ALJ or nobody invoked the interim presumption because there wasn't a full 15 years of employment. But even the law doesn't say that the claimant can't prevail even in cases where the interim presumption is not invoked.
Absolutely, Your Honor.
And so this gentleman had a long smoking history, and he had a 12-year history of coal mine employment. And the ALJ took that into account. There was no misapprehension about the smoking history or about the length of the coal mine employment. He didn't commit legal error.
Correct.
In invoking the interim presumption, which would have been reversible error. But, you know, at the end of the day, why isn't it a matter of dueling sets of experts? I can pick it apart if I've, you know, I can always pick it apart.
Absolutely.
But the question is, in picking it apart, do I lose the forest for the trees?
You would, Your Honor. And, I'm going to cut to the chase. I think I could tell in Mr. Gregoracci's questions that you asked, you have a great grasp of this case. And I want to talk about American Energy because I think I appreciated Judge Wynn's question. In the wake of American Energy, how do we handle these federal black lung cases when we have dueling experts? And I think American Energy is very distinguishable on both the facts, the medical reports, and what the ALJ did in American Energy. American Energy, Judge Wynn did not change the landscape. What it did was, within that particular case, it identified that an administrative law judge needed to do more in how they write an ALJ opinion. In American Energy, the judge simply said, I am crediting the doctors who say things that comply with the preamble, and I'm discrediting those who don't. But in this case, the administrative law judge engaged in a detailed analysis of each of the 5 doctors in separate paragraphs. I've written down about 5 different things that the judge said about each one of these doctors, and at the end of each of those paragraphs, he assigned weight. And he didn't assign full weight to claimants' experts either. I think that's a critical point. The formulamatic, approach that Mr. Gregoracci is insisting was applied in this case really was not applied. If you look at Dr. Raj's report, the administrative law judge actually said, this report is generally reasoned and documented, but it's entitled to diminished weight. And the reason is that he didn't understand the smoking history in the same way that I found factually. The ALJ said that he had a 30-pack year smoking history. Dr. Raj had a 15 to 30-pack year smoking history at half a pack to 1 pack per day. The judge
tend to be a fan of standards of review. In a district court context, the clear error standard means something to me, and the abuse of discretion standard means something to me. And then in this context, the substantial evidence standard means something to me. All these standards of review have one thing in common, and that is they preserve as the domain of the ALJ or the trial judge those particular functions for which they are closest to and in the best position to appraise.
Absolutely.
And then when it gets to a question of law, that's a wholly different matter, because then you have the appellate expertise and the appellate function coming into effect with a de novo standard of review. But where the standard of review is a deferential one, and substantial evidence. I mean, everybody tries to make these factual findings and substantial evidence determinations into a question of law. We have, you know, all sorts of appeals transforming questions of fact into questions of law.
Right.
But I'm wondering again at the end of the day why we should toss what it was meant to be a deferential standard of review aside.
You shouldn't, Judge Wilkinson. That's my point. I totally agree with you. You shouldn't toss it aside. But I do think it's important to distinguish American Energy from this case, because that is the most recent published case from this court. And I think it's clearly a very different case from American Energy. And as I was saying, I think, you know, that's evident in the fact that in American Energy, the administrative law judge commingled medical reports, commingled different elements of entitlement. The judge considered all of the expert opinions together. The judge kind of just made a blanket decision that those who said statements that were similar to the preamble are credited. Those who did not are not credited. In this case, it's clear that the administrative law judge went into each and every one of the medical opinions and provided a separate analysis for each. And he did criticize and scrutinize the claimant's evidence. He said things like, this report is limited to a single exam, whereas Dr. Rosenberg's report had reviewed the whole
I might
record.
have credited a different set of experts, but the point we always make with the abuse of discretion standard is that even if we would have exercised our discretion differently, that's not dispositive. And even if we felt we were going to credit a different set of experts, that's not dispositive in terms of it's not what we would have done. It's what the trier of fact did do.
Absolutely.
That's, you know, maybe I can be persuaded that this is some big question of law, but I'm not there yet.
It's not, Judge. It's not some big question of law. This is a case that's in the wake of American Energy. It's very different, and American Energy did not change the landscape. American Energy simply states that a judge has to give the reasons why he credits an expert and discredits another. And in this case, the warning, I would say, from American Energy was completely met by this particular ALJ, who did give those reasons, those explanations, who did apply the law. American Energy also stated that the ALJ may very well have reached the very conclusion he did, but we just don't know. That's what this court was saying. The judge had not provided enough of an analysis to where it could affirm.
It is a bit hard to believe that a 27-year smoking history. I don't know how many what kind of a pack a day smoking history is. It's hard to believe that the 27 years of a smoking history was not the major cause of what happened here. I mean, just as a simple matter, I would think that 27 years of manifestly unhealthy habit supersedes 12 years in the coal mines. But I don't know, the law doesn't read that way. The law reads, you know, you can have contributing causes, and if one thing is a significant cause or a material cause of the pneumoconiosis, then that's a basis for recovery. So I can say to myself, well, the 27 years ought to be the major cause, but it's also hard to believe that the 12 years wasn't a substantial contributing cause, and the 27 years plus the 12 years of coal mine employment on top of that just ravaged this poor gentleman's lungs.
Absolutely, Your Honor.
And that's...
Two points in response to that. The 12 years was actually 12 years at 12 hours a day, 6 days a week. And I do think that's important because that's exposure. But Mr. Gregoracci made the point multiple times during his portion that the question should be, which one is it? Is it coal mine dust exposure? Is it cigarette smoking? Which one contributed to the chronic obstructive pulmonary disease? That's not the right question. The question is, was it solely coal mine dust exposure? Was it solely cigarette smoking? Or was it a combination of coal mine dust exposure and cigarette smoking? Mr. Gregoracci would have the court basically go in and reweigh the evidence and say, you have to prove one or the other. But the claimant's experts in this case clearly do explain the very point you just made, Judge Wilkinson. They said, we're not eliminating the significant cigarette smoking history, but we're also implicating the significant coal mine dust exposure history. Those two things are both cumulative and additive to cause this man to be in the condition that he's in. The judge didn't have to accept that opinion. He didn't have to credit that opinion, but that's a fact finder's decision. And when he was presented with two opinions that said, I believe it's only cigarette smoking, and he was presented with three opinions that say, we believe it's a combination of cigarette smoking and coal mine dust exposure that's caused the impairment, that boils down to a factual finding and a battle of the experts. And this court's standard is, can we figure out what the judge did and why the judge did it? The answer is clear. He provided 5 separate paragraphs. He went in and analyzed each of the 5 reports separately. He explained why he credited the physicians he did. He explained why he discredited the physicians he did. Then at the end, he weighed them all together. That's a model approach for a fact finder. That's what this judge did. You can tell what he did, why he did it. And Judge Wilkinson, I really do believe that this case is a simple issue, as you said.
You've covered a lot of this in your brief.
I have a lot of
this. If there's anything further you have to add, that would be fine, but I'm going to ask my friends on the panel whether they have some questions. Judge Niemeyer? No. We don't. Thank you.
Thank you, Judge Wilkinson. Thank you, Judge Niemeyer, and thank you, Judge Wynn. We would respectfully request the court to affirm the decision of the administrative law judge and the decision affirming from the benefits review board.
Counsel, we have no questions.
Thank you, Judge.
All right. Mr. Gregoracci?
Thank you, Your Honors. Now, my friend on the other side, he is truly a friend, but he has mischaracterized my position here. It's not, was it smoking? Was it coal mine dust exposure? It's what three options is it? Could it be just smoking? Could it just be coal mine dust exposure? Could it be a combination of the two? The problem is the ALJ looks at this and just says, all right, I'm just going to add up smoking, coal mine dust exposure. There it is. The formula's met. Now explain why it's not met. That's the problem. And when we get into this consideration, is this a weighing of the evidence? Is this a battle of the experts? Can this panel, can these judges here, can you look at what the ALJ did? Well, when looking at what the administrative law judge did, we also have to bear in mind the standards set by American Energy. And this is the problem in this case. Quote, an ALJ must not credit a physician's legal pneumoconiosis opinion as consistent with the preamble merely because it identifies coal dust exposure and smoking as dual causes of a minor's respiratory impairment. Yet, that is precisely what the ALJ did. Now, that quote applies directly to this case. I cited in my brief, and we've talked about the specific reasons that the ALJ gave. Well, there's smoking, there's coal mine dust exposure. They got to combine. They must be additive. There must be legal pneumoconiosis. And now, as my friend on the other side, he said, well, wait a minute, the administrative law judge gave due scrutiny to the medical experts. Well, this is an assertion that is demonstrably false. Dr. Forehand, one of Mr. Lawson's medical experts, made a fundamental misinterpretation and mischaracterization as to the pulmonary function testing evidence. Dr. Forehand thought that there was no response to bronchodilator therapy, and he said, well, that lack of response, that points to the role played by coal mine dust exposure. You know what? The subsequent pulmonary function testing proves Dr. Forehand's assumption and conclusion completely invalid, because the subsequent pulmonary function testing does show the response that he thought didn't exist. Now, had the ALJ actually looked at this evidence and actually assessed the rationale and not applied some formula, we might have a different conclusion as to Dr. Forehand. His opinion is based on inaccurate data. He fundamentally misinterprets pulmonary function testing evidence. Because he relies on that, it's based on misinformation, and this court in Lane v. Union Carbide Corporation has said that such an opinion is completely invalid and unreliable. The ALJ just didn't even pay attention to it, because why? There's smoking, there's coal mine dust exposure, let's add them up. There you go, that's legal pneumoconiosis. That's false, it's also prejudicial error. So what we have here, Mr. Lawson has the burden of proof. The opinions from his experts are not sufficient to meet that burden. The problem is not that they don't apportion or identify specific contribution from smoking or coal mine dust exposure. The problem is that his physicians opine that it's equally possible that Mr. Lawson has lung disease due to coal mine dust exposure, or due to smoking, or due to some combination of the two. And the ALJ took that possibility and made it a reality by applying a formula. This is incorrect. This is not sufficient under this court's precedent in American Energy, Island Creek Coal v. Compton, U.S. Steel Mining Company, CWP Fund v. Mullins. For these reasons, Your Honors, I would respectfully urge that this decision, give it due scrutiny, give the administrative law judge due scrutiny. Look at the rationale supposedly provided by the administrative law judge. You'll see he's simply identifying the existence of these two causes, which was found invalid in American Energy. And I urge you to reverse the award of benefits.
Thank you, sir.
Good, thank you.
We will come down and greet the attorneys. We thank you both, and then we'll move into our final case. Please be seated, and Ms. Harrell, we'll be happy to hear from you.
Good morning, Judge Wilkinson, and may it please the court. I'm Emily Harrell. I'm here today on behalf of Mr. Yacome. And Mr. Yacome has raised some arguments regarding the challenge to the sufficiency of the evidence, but I'd like to focus my arguments on the jury instruction issue, which I'm sure that what you're primarily interested in. Assuming that the plain error standard of review applies, Mr. Yacome, and of course by extension Mr. Flores-Reyes.
Is it plain error or invited error, or both plain error and invited error?
I don't think it can be invited error for a couple of reasons.
What am I supposed to do with the statement that the counsel made, oh, you don't need to re-instruct the jury orally? What am I supposed to do with that?
I don't think it can be considered invited error because,
Well, why wouldn't that imply that the instructions were okay?
well, the instructions,
Or that any errors were really of a trivial nature?
the problem you face, Your Honor, is there is absolutely no way to know whether the correction that the judge made that was placed in the written instructions was actually relied upon or read by the jurors once they were provided the written instructions.
Honestly, you know, there's a lengthy jury trial and about a set of perfectly appalling murders. And you want us to reverse the entire result of that trial based on less than 2 lines of text in 70 pages of written instructions? And we had just to take the entire effort that's been put into the trial, the seating of the jury, the calling of witnesses, the jury's deliberations, and throw that aside and because of 2 lines in a 70-page opinion?
I believe it's warranted, Your Honor, because it is a fatal variance, and it's a possibility that that the jury could have convicted him on a lesser offense of conspiracy based on the court's instruction.
But we're talking about the oral instructions here.
That's
The
correct.
written ones had the correct information in it.
Again, I'll emphasize, Your Honor, there's no way to know whether those written instructions, which contained the corrected.
Was it objected to? I mean, when you think about the practical effect of when you see something, everybody's in the court. Now, you are suggesting the jury heard all this, and nobody really picked up on it until eventually one of the defense counsel picked up on one, government picked up on the other one, and brought it out. And it would have been, the judge seems to me, was very careful in this case. Took his time and gave the opportunity to respond. No one asked him to go back and re-instruct the jury on those charges. You probably didn't need any more instruction on that. It didn't need more emphasis on it. Certainly not the defense counsel. And it's an odd case. And I think Judge Wilkinson's alluded to the fact you got 70 pages. It took 2.5 hours to read it. That would be challenging to me, at least, to do that. And he did emphasize listen, because you do hear it. But he was given copies of the instructions. And in those, I mean, the written stuff is right there. If anybody had any confusion, I mean, I could hear one of the jurors says, oh, he said this, but, well, it's written right here. You know, that would be there. I just don't know of a case like this in which you have this kind of corrective behavior, but you are saying he corrected it, but not enough, is what it sounds like to me.
Yes, Your Honor. I think certainly Rule 30 provides, and the case law that I cited in my reply brief provides, that corrections to instructions should be given in open court so that not only the defendant and attorney have a chance to read and hear and assess the instruction given, but also—
The judge said that the written instructions were to be the definitive ones.
There's nothing in this case, Your Honor.
And the other thing is, you make a big deal about conspiracy here, but these folks weren't just conspiring to commit these horrific murders. They were in it up to their eyeballs. And there's a wealth of evidence before the jury that these three individuals were either principals in these horrific homicides or at best were still aiders and abettors. They weren't conspirators. They were people who were in it and up to it and killed in order to get a promotion and ingratiate themselves with their superiors in a perfectly deadly enterprise. And the jury saw that, and the probability that they convicted them on a conspiracy count as opposed to seeing their active involvement in these horrible acts, the probability that the jury went that direction is between 0 and 0.
Respectfully, Judge Wilkinson, I disagree. I think that there is sufficient evidence, particularly as to Mr. Yacome, where he could have been convicted based on a conspiracy offense. He's only indicted as to this and implicated in this one offense. And there's plenty of evidence that one could take to establish his involvement in a conspiracy. So I would take a different tact on that.
You mean as opposed to aiding and abetting?
Yes, sir. I
I
think
thought Yacome went to the scene and actually participated.
he did, but if the jury were to disregard that, they could also say he was involved in the conspiracy of
Yeah, but how do you
planning.
disregard the vivid description of what took place? Is this, what is it, 14-year-old person who was talking to the police and had to be taken out? Is that the issue? I mean, he was knifed, and did Yacome actually himself apply some knife wounds to the child?
Your Honor, there were some knives involved, and there was.
Was there evidence that Yacome himself applied some knife wounds?
Actually, no, Your Honor. The evidence.
I thought that after they were killing him, he came on and he himself did some.
There's, and I hate to get down into the nitty-gritty details
Well,
of
that's what the jury heard, you know.
There was a machete involved, and there were knives involved. And the government star witness specifically talked about two different instruments. And he talked about the Katra, the government star witness, talked about his and Mr. Yacome's involvement with the machete, which he said they used to strike the victim. And as Mr. Yacome also attempted to strangle him, the handle broke. The other individuals involved in.
So you don't think that was participating? I mean, you think he thought he was just trying to injure this young man?
My position is that those could be taken as part of an assault, that as part of a corte assault. So that would be my position.
Wasn't it a rule of MS-13 that this 14-year-old would have to be killed?
It was a rule, and
Yacome was he a homeboy at that point?
he was a homeboy, but there's no evidence, and I think that there is evidence that perhaps he became a homeboy without committing a murder. So my thought would be
Well, I'm not talking about whether he achieved homeboy, but he was a homeboy status, which is a pretty high up in that organization. And he's in the car, he's going down to the scene, and the rule is that this young man has to be killed, and he gets in there with a machete or whatever, and he's trying to choke him around the neck, obviously to carry out the rule. I mean, I don't quite understand where you would argue that a jury is considering simply a conspiracy charge here.
I think there's sufficient evidence to establish his involvement in a conspiracy. If you take the...
Well, sure, every crime that's actually committed has inherent a conspiracy because you're planning to do it. But the fact that it was actually done in this case...
If you take the position that his homeboy status in the organization established that he would be involved in carrying out the need to eliminate.
Judge Niemeyer makes a good point, does he not? That a great many people who commit a crime, not everyone, but a great many people talk about it beforehand. But that doesn't mean that the jury could have convicted them of a conspiracy when they went a great deal farther than talking about it or conspiring about it or whatever. And it's the actuality of what happened here, not some sort of conspiratorial planning that was front and center before the jury. That's what they heard. They heard, and a lot of it was kept out because the trial judge didn't want to run across a 403 problem. But what the jury heard was not about conspiracy. The jury heard about the commission of the crime, not the conspiracy to commit, but the commission. It's a tough case. It's a tough case for you. But that doesn't lessen my appreciation.
Thank you, Your Honor.
Mr. Goldman, we'd be happy to hear from you.
Thank you, Your Honor. Peter Goldman on behalf of Breon Alexander Contreras-Avalos. It's a pleasure to be here this morning. May it please the court. I'm going to be brief. I've asked for brief time, and I would like to just review with the court, pursuant to my argument, 3 points. The first, I think it's worthwhile to review the standard and the interplay between Rule 29A and Rule 33A. Quoting from this court's case in Souter, which references this court's decision in United States versus Wilson, 118 Fed 3rd 228 from 1997. Reading from Souter, contrary to the government's suggestion, however, Wilson does not hold that a trial court is foreclosed from granting a motion for a new trial in every case where the evidence is legally sufficient to support a jury's verdict. And while Wilson teaches that, quote, a district court should exercise its discretion to grant a new trial sparingly, and that the district court should grant a new trial based on the weight of evidence only when the evidence weighs heavily against the verdict. We evaluate such a ruling against the backdrop of the district court's broad power to independently weigh the evidence when considering such a motion, as well as the deferential standard of review we must apply to that decision. My point being that, unlike Rule 29A and a Rule 33A motion, the district court can and should make its own credibility determinations and review the evidence. Now, this court reviews the district court's denial of the 33A motion on an abuse of discretion standard. With that said, the next point I'd like to make very simply is, and that relates my 2 points, I'd like to read very briefly what began this trial, which was the testimony of the government's hand-picked expert, Sergeant Ricardo Guzman from the Houston Police Department, about the credibility and the need for corroboration of MS-13 cooperators. Question, and also getting back to when they lied to you as law enforcement, you have learned that it's best to not just rely on their word, correct? Answer, that's right. Question, and to seek other evidence that can corroborate one way or the other what they are saying. Answer, yes, ma'am. That was the government's expert that began this case. I have very little time, so briefly, I think, and if you've read the brief, my argument very simply, the case against Mr. Contreras-Avalos was not based on any physical or forensic evidence. The government, and this was a 6-year investigation, the government had numerous government attorneys, FBI, DEA agents, crime scene investigators, police DNA investigators, and other federal and state personnel. But in this case, there was The government was unable to produce any physical evidence, forensic evidence, weapons, drugs, DNA evidence.
Thank you, sir.
Yeah.
We appreciate it.
Thank you. And I'll reserve a word for rebuttal.
You have reserved a minute for rebuttal as well.
Thank you.
We'll hear from you. Mr. Sachs, let's hear your view of that.
Thank you. May it please the court. Ethan Sachs on behalf of the United States. I'd like to start briefly with the jury instruction issue we've been talking about. I think Your Honor's discussion with my friend on the other side really gets to the key issues here. Just to clarify, more is the case that we think lays out when an error in the jury instruction can rise to a constructive amendment. What Moore says is you consider the totality of the circumstances and whether those circumstances would allow a reasonable jury.
Well, this issue comes up occasionally, but other circuits have faced what were alleged to be variances between written and oral instructions. And when the written instructions were submitted and were conveyed to be definitive, as I understand it, the other circuits have said that there's certainly no plain error in those sorts of circumstances. So I think if we were to say that there was a fatal variance in what happened here, that we would be creating a circuit split in terms of the way that other circuits have approached this question about, because, you know, it's not an unusual thing for written instructions, of course, aren't always given, but where they are, it's not an unusual thing that they don't parrot verbatim what was said in court. And if any little difference there was thought to be some kind of fatal variance, that would be a pretty unsettling holding. See what I'm saying?
Yes, Your Honor, absolutely. We agree with that completely, especially in light of the context of how minor the mistake here was. I mean, it was 2 words or references to the word conspiracy, and as Your Honor's alluded to earlier.
What
I'm sorry?
My friend Judge Wynn said, and that is you cannot read the record here and go over this without being impressed with the manner in which Judge Dennis handled this trial. She's a very good judge, I might add. And she, notwithstanding the horrific nature of these crimes, she bent over backwards to make certain that there was a fair trial here, as she should have done. And sometimes you like to respect good work on the part of the district judges. They value their craft as much as we value ours. And this district judge did a fine job.
Well, we agree, Your Honor, that the judge here was very thorough in the district court in understanding of all objections. And in fact, this issue only came to rise because the district court judge, after reading the jury instructions, elicited comments from both sides and ensured that there wasn't anything substantial or serious enough worth to recall the jury. So I think we agree that throughout the trial, the judge was conscientious and aware of any potential concerns, and certainly none arose to the level of the amendment.
Judge Niemeyer, do you have any further questions on that? Judge Wynn? We have no further questions. We thank you.
Great. Thank you very much.
Ms. Harrell?
Just briefly, Your Honor, you mentioned several courts looking at the issue of jury instructions and perhaps finding plain error or not. I guess I would say that the error exists in the fact that there's absolutely no way to determine whether the jury read and relied on the instructions.
Well, sure, there's a way to determine it. You can look at the evidence that was presented to the jury.
And there's specific findings. They made some specific findings in this case.
They made specific findings as to count 1.
Yes?
And I believe my position on that would be the counts are to be considered separately.
Of course.
And so I don't think you can automatically transfer the finding made on count 1 to the Vicar murder on count 5.
Didn't the district judge, and I'm asking you, I can't remember, did the district judge go through the different counts and explain the different counts?
Yes, and that's where the error arose.
And the court did not include a Pinkerton count, right?
I'm sorry?
The court did not include a conspiracy count.
Correct, as to count 5.
No, I'm talking about all counts.
She did include a Pinkerton count as related to count 1. So she included that charge there, but then the whole issue arose at the charge conference because the government also wanted a Pinkerton charge as to count 5. And counsel objected, and then it evolved into an Apprendi issue. Well, if I include this conspiracy language, then I've really got to consider whether we're creating an Apprendi issue. And so they agreed to take it out. And then there was an inadvertent inclusion of it in the charge that she read to the jury the next day on count 5. So that's where the error was.
Well, I know where the error was, but I'm trying to put myself in the position. You're focusing heavily on the oral presentation, and it was a lengthy presentation. And traditionally, and I must say, I confess I didn't go back and look at the beginning, but usually the judge outlines the various counts that are being presented to the jury and describes them generally and then does it in more detail later. But I was asking whether that was done in this case.
Yes, Your Honor. In her opening charge, like at the very beginning of the trial, she just gave a very brief overview of counts, obviously. But then when she went to charge the jury, and she charged before they presented closing argument. So when she charged the jury as to all of the counts, she did include a Pinkerton charge as related to count 1. But again, I would just circle back very quickly to the fact that even though the jury made those findings, you have no way of knowing whether they read and relied on the corrected instruction they were given. She didn't poll the jury when they came back in. Contrary to the government's argument in their brief, she didn't tell them, hey, rely primarily on these written instructions. Those things did not happen. So, thank you, Your Honors.
Thank you. Mr. Goldman?
Your Honors, briefly, from Mr. Contreras-Avalos' point of view, the record of this case is very strange. The entire conviction of the evidence against my client was based on the testimony of cooperators, which I realized that there was
I understand. You know, the jury knew this, and as much hay could be made of it. The jury makes the assessment. You and I both could make the assessment. We know this is a hardened criminal that's testifying, and we conclude he's testifying because he's going to get a break. And so the cross-examination goes like, well, how do we know you're truthful now? I mean, this type of thing. The jury makes that assessment, and there was plenty of evidence, that oral evidence. I mean, you obviously would like some forensic evidence presented, but that isn't totally unusual.
Correct, Your Honor. You're right. What is unusual about this case is that the government's expert, the first witness of the case, said these people, cooperators, cannot be believed without corroboration. That corroboration is not in the record of this case against my client. We respectfully submit, I agree with you, Judge.
That's his opinion. I mean, if the jury believes him, the jury believes him. He says, oh, you can't believe them because they're criminals. They've been at this a long time. They're in a very lethal gang. They've done some very bad things, and they're in here testifying, trying to save their soul. So the expert says, don't trust them unless they're corroborated. Well, that doesn't bind that person. Doesn't even bind the jury.
It doesn't bind the jury. I respectfully submit it creates a problematic record to convict.
I don't even know if it's problematic. It seems to me that's like an expert saying, basically, be careful. These people are criminals. They were involved in all of this, and they're now trying to save their skins. This is what the jury knows and has to assess. But that doesn't deny a person evaluating the testimony based on how it's said, what's said, how the witness acts, how it's consistent with other witnesses' testimony, how it's consistent with the overall structure of the case. These things the jury sees, and it doesn't look like they had much trouble on this case.
I appreciate the court's position. If I could just make, Judge Wilkinson, one other
Sure.
point. Sure. Thank you, sir. In addition to, I think, that the government's case collides with itself, when the one expert presented in the case said, I always have to corroborate these people's information because they're not believable, there's also just a basic logic and common sense problem. How could my client, Mr. Contreras-Avalos, be involved in this gang for 6 years, doing all these allegedly horrific things, and out of that alleged criminal activity, and with this legion of investigators and resources the government threw at this and had testified, how could it not produce any physical or forensic evidence?
All you have to do is look at the whole history of the mafia convictions and prosecutions. I mean, the leaders of these organizations isolate themselves. The big drug conspiracies we have, the heads of them usually don't even touch the drugs. It's the way these operations operate, and this is something for the jury to assess and for the evidence to be presented. Now, if there's not enough evidence to hold them in, the jury they're sufficiently informed about it. I'm sure you informed them well about it. But it seemed to me that it's hard to get the leaders of these organizations who isolate themselves from the actual conduct. They'll flick their finger and give the green light, and 2 people are killed upon sight. And they say, oh, you can't get him who flicked his finger for the green light because there's no forensic evidence. As a matter of fact, he didn't even say kill him. He just went like this. This is the green light. That's the way they operate.
I understand, Your Honor. I appreciate the court's position.
Right.
Thank you very much.
Thank you. I see you're court appointed. I mentioned earlier it was a tough case, but I really am all the more appreciative for your willingness to step forward and provide what I think is a very able defense. So thank you both. You really do have the court's appreciation. And we'll come down and we'll adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.